significantly, what I want to share with you this evening is that over the last 8.5 years, each of you has been truly, truly responsible for my own evolution as a judge. Your insights of your cases, your arguments, small, not so small, large, have shaped the outcomes of cases. I can see faces in the hall today who have changed us in a rejoinder when you felt that, well, the respondents were absolutely dead right. And then a young advocate on record got up and rejoinder. And you just felt I was so completely wrong. The balance of justice lies with this side. That can also be called, as we used to call as members of the bar, of Bengal ki thali, that is who change between the petitioner and the respondent and the petitioner again. I don't really know whether I was a Bengal ki thali, in that sense. But I certainly know that in my court, that the person who shouted the most didn't necessarily get the best order, nor the person who spoke the last. Because people who shout the most sometimes, prey on the mental calm of the judge. And there's a wrong perception that orders are obtained by those who are aggressive, who shout, who try and bully the judge. It doesn't work like that. Because there is a great element of discretion which a judge has, not in converting the right into wrong or the wrong into right. Because when there is a wrong, you have to say it's wrong. When it's right, you have to say right. But the real issue arises in those gray areas when everybody is searching for the truth and everybody is searching for where the truth really lies. Because so often, the most difficult cases are not cases between a conflict of right and wrong or polar opposites. The most difficult cases are cases where there's a conflict of right and right or wrong and wrong. And when there's a conflict between right and wrong, that's when the craftsmanship of the judge comes up, and that's when the human element comes up. So far from advocates on record who are more, I wouldn't say docile, because the art of advocacy is not in being fair, but in being persistent, but persistent with a degree of civility. I always find when recommendations of the collegium come up before us that judges in the High Court, if we especially interact with them, say that some person is very fair when they appear for the government. Reading between the lines, when the judges say that somebody is very fair appearing for the government, means that the judges are very happy that they are conceding every point. That is not the hallmark of a good advocate. The hallmark of a good advocate is to tell the judge that this is where the balance of justice lies, this is the correct position in law, and not in that sense being subservient to the judge. But you need not be subservient to the judge while at the same time being civil with the judge. And civility is unfortunately a dying art. But for those of you who still pride yourselves for being civil in court, let me assure you that you are walking the right path. Too often you find that, the temptations to cut corners in a court are so many. Because you always wonder that, maybe I'll lose a brief if I don't yield to temptation, if I'm fair to the court. But at some point of time, the law, destiny, whatever you call it, tends to catch up if you're easy with the truth. And so many of you who have appeared before me, I'm very happy to note, have not been easy with the truth. And because you've not been easy with the truth, that reputation grows over a period of time. So I would really not take much time, but end by first and foremost thanking you for the tremendous support which you gave me through the years, which is evidenced by this large number of people, so many of you who have come here and are standing in the ranks here just to hear me speak. So thank you first and foremost for giving me all your support. Second, I must thank you for your patience, because I can't pride myself on knowing every branch of law. When I came to the Supreme Court, I had no real experience in deciding criminal cases. Because in Mumbai, we were also specialized. And so also in Allahabad, I was the Chief Justice, so I could pick up what I wanted to do. The Chief Justice always has that prerogative. Because when I came here, that I, for the first time, learned how to do a criminal appeal. I sat with Justice Lalit and I sat with him for a good number of months, and I told him that I'm just going to observe you, analyze evidence in a criminal appeal, understand how the nitty-gritty of a case has to be unraveled in a criminal court. And I learned such a great amount from his own perseverance and perspicacity about criminal work. So I must thank you for your patience in bearing with me at a time when I was still trying to learn the ropes. Because the great difference between High Court advocacy and the Supreme Court is that in the High Courts, we take up an assignment and you work on that assignment. So when you work on that assignment for say 6 months, you've worked on tax, you're doing only tax. You're doing bails, you're doing only bails. In the Supreme Court, you are switching from consumer protection to service to bails to maybe a PIL. There is no one line of work that you are doing. And therefore, that requires a great deal of versatility on the part of the judge. Our colleagues from the bar have that versatility, which we don't necessarily have coming from the High Courts, but we pick up the rhythm of the work as we come to the Supreme Court. So second, I want to thank you for having shown great patience with me during the time that I was evolving with the Supreme Court. Third, whether or not you got a favorable order, nobody questioned my motive, which was, I think, a sense of great faith that I had in all of you. And finally, I want to say that I hope that a lot of you will go from strength to strength. Many of you would become judges of the High Court. I think it's very important that the advocates on record from the Supreme Court who come from different parts of the country must fan out to different parts of the country and accept the offer of judgeship or pursue that alternative as a career option in due course. Because there's something about Supreme Court advocacy which marks you out from High Court advocacy. The High Court bars are a little, they're a little careful about accepting lawyers from the Supreme Court as judges of the High Court. There's one thing that the Supreme Court bar has, and that is the ability to look at law from a national perspective. When I was a lawyer at the High Court, I always looked at law from the perspective of my own state. I learned to look at law from a national perspective when I became a judge here. And I realized that the same applies to members of the Supreme Court. Because by virtue of the fact that you pick up that order from Karnataka, from Kerala, from West Bengal, from Tamil Nadu, from Maharashtra, you realize the interrelationship of the law as it cuts across different regions, different states, different cultures. That makes for a more well-rounded judge. So I conclude by wishing you all the best. Thank you for this beautiful evening that you have given. Thank you, sir.